Tonight, a Commitment 2016 WISN 12 News election special. A conversation with the candidates for Wisconsin Supreme Court. The incumbent, Justice Rebecca Bradley, appointed by Governor Walker in September, is seeking her first elected 10-year term. The challenger, Appeals Court Judge Joanne Kloppenburg, ran for Supreme Court in 2011 and narrowly lost to Justice David Prosser. Tonight, the candidates on their views of the law, the role of the Supreme Court, and recent controversies in the race. And now, live from the Marquette University Law School, here is tonight's moderator, WISN 12 News political analyst and upfront host, Mike Goucher.
And good evening, everyone, and welcome to our conversation with the candidates. Once again, we are live at Eckstein Hall at Marquette University Law School, where I work as a fellow in law and public policy. This is our third and final debate before the April 5th election. Tonight, we have the candidates for Wisconsin Supreme Court, Justice Rebecca Bradley and her opponent, Appeals Court Judge Joanne Kloppenburg. This was a very close contest in the February primary. Bradley and Kloppenburg advanced from a three-person field, Bradley ahead by 2% of the vote. Our rules for tonight are pretty simple. I'll be asking the candidates about their qualifications, their judicial philosophies, their differences, and some of the recent headlines in this race. I'll be asking them to answer those questions directly and concisely and to stay on point. The candidates can certainly talk to one another, but I'll manage the time on any given topic and we'll have the freedom to move the conversation along. Near the end of our hour, each candidate will be asked to make a closing statement. And so we begin with the first question for the incumbent, Justice Rebecca Bradley. And good to have you here. And I should say also, Judge Kloppenburg, this will be the same question for both of you, because we think this is a bit of a getting to know you session here. And I say that because right after the February primary, the Marquette Law School poll, and you know we do some polling here at the law school. The law school poll said that 60%, Justice Bradley, 60% of the people we surveyed didn't have either a favorable or unfavorable opinion of you. 57% didn't have a favorable or unfavorable opinion of you, Judge Kloppenburg. So you're kind of a blank slate for a lot of people in this state. And I'd like you to begin by helping inform people about who you are, your qualifications. Give them a sense of who you are.
Well, I was born and raised in the city of Milwaukee, and I've lived in Wisconsin my entire life. I graduated from the University of Wisconsin Law School 20 years ago, and I practiced law for over 16 years in the private sector. I was a civil litigator, a business transactional attorney, an American Arbitration Association arbitrator, and vice president of legal operations for an international software company headquartered right here in Wisconsin. After practicing law for over 16 years, I felt called to serve the people of Wisconsin as a member of the judiciary. And I was really honored when the people of Milwaukee County elected me with almost 54% of the vote to serve as a Milwaukee County Circuit Court judge. I served in children's court, where I dedicated myself to strengthening families, protecting children in need, and keeping my community safe. I also served on the Wisconsin Court of Appeals in District 1, Milwaukee County, and now I serve on the Wisconsin Supreme Court. And when I say I felt called to serve the people of Wisconsin as a member of the judiciary, what I mean by that is that I really believe it is important that we have judges, and especially justices, on our state's highest court who understand our duty to say what the law is and not what we may wish it to be.
We'll come back to that point in just a minute, but Judge Kloppenburg will give you the same opportunity to introduce yourself to those folks who don't know a lot about you at this point.
Sure, and I would echo that this race is about the future of our court, about what kind of court it ought to be and what kind of justices we should be electing to the court. I was elected to the Court of Appeals in 2012. I've issued hundreds of appellate court decisions in all different areas of law in the 3.5 years since. I am one of 16 judges who serves on the Court of Appeals. Statewide, we handle about 3,000 cases a year. I have great respect for my colleagues, even though we don't always agree, and I'm honored that they chose me to be the presiding judge of my district, which sits in Madison, but we do get cases from all over the state. Before I was elected to the Court of Appeals, I served as an Assistant Attorney General at the Wisconsin Department of Justice for 23 years. I was hired by Don Hanaway, a Republican, by Acing the civil service exam, I served under 4 attorneys general from both political parties, representing the interests of all of the people of Wisconsin in circuit courts around the state. I argued many times in the Court of Appeals, many times in the Supreme Court, and did the same in the federal courts at all levels. I handled many different areas of law, constitutional, administrative, appellate, all aspects of civil litigation, and I also handled environmental cases, helping to keep our air and water clean throughout the state. Before I went to law school, I served in the Peace Corps with my husband, Jack, who is from Milwaukee. We were there for 3 years in Botswana, an African nation. I planned and obtained international financing for rural development projects around the country. We returned to the States. I started the Federal Nutrition Program for women, infants, and children in 2 poor rural counties in upstate New York. I was also a college administrator at a small liberal arts school and at the Cornell Business School. We moved to Madison in 1985, where we've lived in the same house and raised our 3 kids since. I started law school right away with the 2 oldest of those kids. I paid my way through by teaching legal writing. I interned for Justice Shirley Abrahamson. I graduated with honors and awards, clerked for Chief Judge Barbara Crabb for a year before joining the Department of Justice. And I now serve on the board of a foundation that provides legal services that gives grants that provide legal services to low-income families and victims of domestic violence. I've been teaching at the UW Law School since 1990. I'm a volunteer mentor, and I have continued to serve on boards primarily involved in providing legal services to low-income families and victims of domestic violence.
I'm going to get right to the issues, and thank you for your opening comments, both of you. Justice Brantley, you began to touch on this at the end of your remarks about why you feel this is so important to the people of Wisconsin. Why should they care about this election?
The people of Wisconsin should care very deeply about this election because it's really about, and I think the main issue in this race is about judicial philosophy. We've been on the campaign trail now for several months, and one of the most frequent questions we receive is which United States Supreme Court justice are we most philosophically aligned with? And I have consistently cited the late Justice Antonin Scalia. America has suffered a great loss with his passing. And Justice Scalia was at the forefront of a movement of judicial philosophy that focuses on the original meaning of language used in our Constitution and in statutes and other law. He was a textualist. He applied the words of statutes, the words of the Constitution, and he always followed the law and applied the law as it was written by the people's elected representatives in legislature and as it is written in our state and federal constitutions. He always followed the law, even if he personally disagreed with the law or with the outcome in a case. And that is what this election is all about. My opponent has consistently cited as the justices on the U.S. Supreme Court that she is most philosophically aligned with Justices Ruth Bader Ginsburg and Sonia Sotomayor. These justices have a very different judicial philosophy, and therefore my opponent does as well. They believe that the Constitution is a living document that should change to reflect changing social and political conditions, that it doesn't mean what the text actually says. And having this type of philosophy allows a justice or a judge to introduce his or her personal beliefs, policy preferences, and political inclinations into their judicial decision-making. I completely reject that judicial philosophy because it is the role of the legislature, the people's elected representatives, to set the policy in the state of Wisconsin.
Defer to elected officials, defer to the elected branches of government, is what you're saying?
Yes, unless they intrude on the Constitution.
Judge Kloppenberg, tell us about the philosophy. Obviously, you feel that's what's key in this race.
No, actually, what's key to this race is keeping partisan politics and special interests off the court. I alone have been to all 72 counties, and people are telling me they want a court that is independent, free of partisan politics, free of special interests, and not dominated by Scott Walker. And that's what we saw by the results of the primary, when you had 55% of the people voting for Judge Donald and for me voting for change on our Supreme Court. People get what the court ought to be. It ought to be a place where everyone feels like they've had a fair shake, where every justice approaches every case with an open mind, where the outcome of any case is not a foregone conclusion. In short, it should be a place where people are confident that justice is being done without fear or favor. Everywhere I go, people tell me they want all three branches of government to work for them, they want their local governments to be allowed to work for them, and they want the court to serve as the independent check and balance as it was designed to be. And that's why I'm running, because I'm unwilling to surrender our court to partisan politics and outside special interests that threaten to undermine its independence and integrity. And that's what distinguishes me from my opponent. I am the candidate people can count on to bring independence, integrity, and experience to the court. And in terms of judicial philosophy, as my opponent has described hers, it's really in the form of slogans that you can find on the website of the Federalist Society website. Justice Scalia espoused a very extreme judicial philosophy that wasn't shared by the other people on the U.S. Supreme Court, by his colleagues. And my judicial philosophy is evident in the hundreds of appellate court decisions that I've issued as a Court of Appeals judge.
Let me jump in there. You said that at a couple of different events, and let me just follow up on this. You've referred to the Federalist Society as extreme. And there are probably people in the Federalist Society who would say, how are we really any different than the progressive counterpart to us, which is the American Constitution Society? Are they also extreme, or does that depend on your political view?
They probably are as well. I haven't been a member of either. And the point here is that I have shown through my hundreds of decisions that I am an independent, fair, and impartial judge. I approach every case with an open mind. I apply the law, of course, as it is written, because that's where it is. And I apply the law to the facts fairly and thoughtfully in a principled and disciplined manner to answer the legal question that is asked by the parties. I have great respect for the role of the court as an independent check and balance on the other branches of government. And my duty is to uphold the Constitution, which represents the will of the people and contains the fundamental principles that define our democracy, protect individual rights, and promote a more equal society. And I have cited Justices Sotomayor and Ginsburg in part because they're trailblazers for women who want to follow their footsteps as lawyers and judges, and because they do seem to share my view of the Constitution as protecting individual rights and promoting a more equal society. And I've also cited Justice Kennedy for his ability to form coalitions on the court, which is so important.
And I hope you both understand tonight, I've got a lot of ground to cover, so if I jump in, I will be jumping in. And I just want you to understand that both, so that there's no malice intended. I just want to make sure we get through the material tonight.
Can I jump in? There's quite a bit I need to respond to for my opponent. First of all, my opponent is referring to my judicial philosophy as a campaign slogan taken from the Federalist Society website. Actually, it's taken from the 1803 decision of Marbury versus Madison, which established the power of judicial review. And in that decision, the court said it is emphatically the province of the judiciary to say what the law is. So my judicial philosophy comes from a longstanding history of jurisprudence in the United States of America. With respect to partisan politics and special interests influencing this election, the only person who is introducing partisan politics into this race is actually my opponent. She does not hesitate to tell everybody who appointed me to the bench. Well, the governor, in appointing me to the bench, was doing his constitutional duty to appoint a justice when, as in this circumstance, sadly, Justice Patrick Crooks passed away. I have not heard a single instance in the hundreds of cases that I've presided over, first as a trial court judge, a Wisconsin Court of Appeals judge, and now as a Wisconsin Supreme Court justice, not a single example of my introduction into any of my judicial decision-making, any partisan politics. With respect to special interests, 5 years ago, special interests ran $1.6 million in ads on behalf of my opponent, which I think just about everyone in this room, if they saw them, would agree was probably the sleaziest political ad in state history. That is an introduction of special interests into an election, but at that time, my opponent was not critical of those special interests entering the race on her behalf. And I just wanted to clarify for the record, while I have been a member of the Federalist Society, I have also put on programming with the American Constitution Society, which is the progressive counterpart, and I have also attended their events because as a jurist and previously as a lawyer, I'm interested in a very nonpartisan and intellectual discussion of issues and cases and jurisprudence.
I want to
speak. Yes, I can break stuff in here. I have been consistent in speaking out against special interests from 2011 till now. And as we've both said, we do not, or I have said, I do not and cannot control them. But what's important about partisanship is the fact that each candidate says they'll be independent or impartial when they're on the bench. And the challenge for voters is to determine which one of us is most likely to deliver on that promise. And you can tell who will do that by how we got where we are. And you heard how I got where I was being elected. I owe my judicial career to the people of Wisconsin and have a very nonpartisan background, working for the interests of all the people of Wisconsin for 23 years at the Department of Justice and now 3.5 years as a judge on the Court of Appeals. My opponent was appointed 3 times to 3 judgeships in 3 years by Governor Walker. First to the Court of Appeals in 2012, to the Circuit Court in 2012. She spent about 2.5 years on Children's Court, and then he appointed her to the Court of Appeals in May, and 5 months later, he made the very political decision to appoint her when she was an announced candidate for an open seat on the court to the Supreme Court. And my opponent has brought her partisanship with her into this campaign. She has allowed the Republican Party to provide funding for her campaign staffing and operations. She left during oral argument to go speak, to give a campaign speech to a big money special interest that's closely aligned with Governor Walker. The partisanship is on her side of the table, not mine.
I want to come back to that, but I'll give you a chance to respond, and then I'll follow up with both of you on this. Yes.
With respect to my appointment to judgeships, I also want to remind the voters that the people of Milwaukee County had an opportunity to evaluate my performance on the Circuit Court bench, and they elected me in a hotly contested race in 2013 with almost 54% of the vote. In that race, I had substantial bipartisan support, as I have in this race as well. With respect to GOP funding of my campaign, it simply isn't true. When organizations of any type provide assistance or provide anything in a campaign, they are required to report that to the GAB, and the campaign is required to report that as an in-kind contribution, which happens when organizations or individuals provide that type of support to a campaign, even unsolicited.
What about your appearances, for instance, at a fundraiser last night in Madison, where there are prominent Republican state lawmakers there? Wouldn't that give a reasonable person reason to think that, gee, if Justice Bradley is elected, that she might be more sympathetic to causes and concerns that conservatives would espouse? The fact that you have the governor's support, the fact that you're appearing at events with other Republicans, the fact that the Republican Party is helping, perhaps not financing, but helping, wouldn't a reasonable person come to that conclusion?
I'm going to answer that question, but I just wanted to follow up on one other point that my opponent made. She talks about my appointments to judgeships, but what she hides from the voters is the fact that 3 times she applied for appointments, twice to then Governor Doyle and once to President Obama, and she was not selected for any of those judgeships. And I think that the reason that my opponent thinks that I must be inclined to introduce partisanship into my judicial decision-making is because that's what she would do, and I think that would be consistent with her judicial philosophy. To answer your question, Mike, with respect to any involvement or help I might be receiving from partisan-affiliated officials, I point to the fact that I have support on a bipartisan basis, and I'm willing to accept endorsements and to have people helping me with my campaign and sharing my message across the state of Wisconsin. I know my opponent regularly appears at functions of the Democrat Party. There's nothing wrong with that. Our ethics code allows us to attend partisan events for the purpose of advancing our candidacy. I've said from the beginning of my campaign that I'm happy to speak to any organization that invites me to speak.
Judge Kloppenburg, let me ask the question before you respond. But her point is, and your point is, you say that it is are suggesting, I think, that it's a partisan court, that's how people view it, as being partisan, that these justices, they want a nonpartisan court. And yet, as she mentioned, there was a lot of money spent to try to help you get elected. And I know you say you can't control third-party spending, but it was spent by liberal groups. You have a fundraiser at someone who raises a lot of money for Democratic candidates, Mary Solinger in Madison. You have an endorsement from the AFL-CIO, which says we will try to work to help make sure you get elected, from the State Teachers Union. Why would people think you're going to be less partisan?
Because of how I got where I am proud to have all of those endorsements. And I didn't get those appointments that I tried to get because I didn't have the political connections to get those political appointments. And what is striking and unusual about how my opponent got where she is this fast-track series of appointments. Everybody's been in a workplace, and you have someone elevated from one position to the next, and only 5 months and a handful of opinions later, they're elevated to the highest court in this state after only 3 years of other appointments. That suggests that it's politics, not qualifications, that got her on the court. And I am so proud to have, I'm the only candidate who has people publicly endorsing me from every county in the state. I have groups as varied as the largest law enforcement organization in the state, the Wisconsin Professional Police Association, and the Wisconsin Firefighters, as well as the Madison teachers and hardworking workers around the state supporting me, and I am proud to have their support.
I guess my question in a nutshell, and you can both just take 15 or 20 seconds on this, is this. Should voters in the state ignore the optics of these judicial contests, where they clearly, I think, appear to be, to the average voter, one side is running in this camp, the other side is running in this camp, Democrats here, Republicans there, that's the way it is?
This is why, Mike, I'm emphasizing my judicial philosophy. This is why this is the critical issue. Every judge comes to the bench as a human being having opinions on the issues of the day. It requires a judicial mindset when we put that black robe on to be able to set aside those personal opinions, policy preferences, and political inclinations, and to always follow the law. And that's why I emphasize to the voters my judicial philosophy. This is exactly what I ran on in Milwaukee County when almost 54% of the voters elected me, because what I found out, what I learned from talking to voters across the political spectrum, is that that is exactly what they want in their judges and their justices. They don't want a justice who believes that the living Constitution means whatever a majority of the justices on the court think it means. They want justices who will stick to the law. And I have a record of presiding over hundreds of cases at every level of the court system in the state of Wisconsin of doing just that, always following the law and setting aside my personal preferences and the outcome that I might like to achieve.
Judge Kloppenburg, yes.
Well, and I would note that Club for Growth put in $167,000 to help my opponent get elected in that Milwaukee County race, which was hotly contested. And again, I go back to what is the core, what is at stake here is the independence and integrity of our court, a court that's free of partisan politics and special interests. And again, you can tell how we got where we are. I am the candidate with a completely nonpartisan background. I am the candidate with a proven track record of cases out there in the public, for the public to see for 3.5 years, appellate court decisions written that have established that I am a fair, independent, thoughtful, principled, and disciplined appellate court judge who applies the law to the facts and answers the questions asked by the parties in a clear and understandable fashion. And I am honored to say that I am endorsed by many more judges around the state than my opponent, which I think is evidence of their confidence in me as having shown myself to be an independent judge.
One more question on this partisan discussion that we're having, or discussion about partisanship in the court. And that is, in 2009, the U.S. Supreme Court ruled that a West Virginia State Supreme Court justice had to step aside because of a case that involved a major contributor to his campaign. Wisconsin has kind of gone in a bit of a different direction in terms of its rules for that sort of thing. No endorsement or no campaign contribution, no matter how large, can be cause in itself for a justice to step aside. You could not force a justice to step aside, no matter how much might be contributed. Was that a good change? That was a change in the way we do business in Wisconsin. Was it a good change, Justice Bradley?
Well, Mike, the Caperton decision that you referred to, which was authored by Justice Kennedy, he actually acknowledged in that decision that that was an extremely unusual circumstance where the judge in that case had received millions of dollars from the CEO of the company who had a case pending before him. In that case, the United States Supreme Court said that that was a due process violation with respect to the other party. We are bound to follow the rules, the Code of Judicial Conduct, and the statutes that relate to recusal. If changes are going to be made, those are the types of changes that come to the Supreme Court. Those are the types of changes that I have looked at myself when petitions are brought to us to determine whether changes should be made. Before I would weigh in on whether or not changes should be made to our recusal rules, I would want to follow that process. We hold public hearings. Somebody petitions us to change those rules. And then we hear from the public. We hear from stakeholders in the legal and judicial system, anybody who wants to weigh in. So before I would consider whether we should make changes to those rules, I want to hear from all the stakeholders, anyone in the public who wants to weigh in on the advantages and disadvantages. But I also want to respond to something my opponent said in her last response. Very quickly. She says she has a completely nonpartisan background. It's simply not true. If anyone looks into my opponent's background, they will see that she has closely aligned herself with the Democrat Party and with progressive and liberal causes and Democrat causes before she even became a judge, and she continues to do so during the course of this campaign.
You respond to that first and then the larger question.
I have no evidence of that, but I would like to say that our recusal rules are among the weakest in the nation. And the rule that allows a judge or justice to participate in a case, no matter how much money a party may have given to that judge or justice, was adopted nearly verbatim from the Wisconsin Manufacturers and Commerce in 2011. And I believe that our rules merit review and revision to be more in keeping with rules in the rest of the country. And I would say that I have always been consistent in my position, saying that our rules of recusal should be strengthened. I always say we have a subjective test. It's up to each judge or justice to decide whether they can be impartial. And I think there should be an objective test where to a reasonable person is their appearance of conflict of interest or partiality. And I know that Rick Essenberg wrote a column, I think today.
It was actually a news story in the Journal Sentinel today,
saying that he believes that I'm inconsistent in my views because I didn't recuse myself when part of the John Doe investigation case came before the Court of Appeals. Right. And I did not recuse myself because I did not see any reason to do so, and I believe...
Even though some of these organizations had spent a lot of money to make sure you were not elected in 2011?
Right, and I believe that had we had this objective test in place, that my decision would have complied with that objective test as well. And it's no surprise that Rick Essenberg and I would disagree with each other, and I would note that Rick Essenberg wrote in supporting one of Rebecca Bradley's applications to the governor that, quote, she can expect to receive the strong support of conservatives. She has paid her dues. That will not be ignored, end quote. And I don't believe that service to any political or ideological cause is qualification for service on our Supreme Court.
I'll give you a chance to respond to that, and then we're going to move on to some other ground here.
Okay.
I think my opponent's position is completely inconsistent. What she's basically saying is that if an entity or a person spends a lot of money to help somebody get elected, well, then that judge can't sit on a case that involves them. But if that same organization or entity spends a lot of money against an opponent, well, then that's against my opponent. In this case, the John Doe case, the Club for Growth spent a lot of money against her last race for Supreme Court. Well, then it's okay. She can sit on the case because she can be impartial. You can't have it both ways.
What would you do if you were
work
faced with
way.
that circumstance?
I do what I do in every case. I look over our judicial code of conduct, and I make that determination after I evaluate the facts of the case, the parties who are involved, and sometimes there is a black and white rule that says we can't sit on that case, and sometimes we have to make the determination as to whether or not we can be impartial. But it's my job as a Wisconsin Supreme Court justice to sit on every case that is presented to me unless there is a reason I cannot.
Final point, and then we'll move on.
I'm ready to move on.
Okay, let's move on then. Let's talk about the tone of this campaign, which has gotten tougher in the last week and a half. And Justice Bradley, I'll begin with you in this. The Liberal Advocacy Group, One Wisconsin Now, uncovered some writings that you had done back as an undergrad here at this university. It's for the school paper. Some of them are fairly controversial. Some of them are quite provocative. They deal with issues like abortion. One of them dealt with a comment about date rape. Another issue that came up was gays, homosexuals. And this is 24 years ago, which you have pointed out when you've been asked about this. But you said of gays in one of these columns, you called them queers, and you said that gays with AIDS or HIV were degenerates. I know you've apologized for that, but what would you like to say tonight about those comments then?
I would like to reiterate the apology that I made last week several times to the people of Wisconsin. First of all, I'd like to apologize to everyone in the state who read those comments 24 years ago. I wrote them a quarter of a century ago when I was a 21-year-old college kid. And I have changed significantly as a person, as we all do, as we grow up and experience life and get to know people. And I'm apologizing now to everyone who read those words over the last week. I have said, and I sincerely say, I'm deeply sorry for those words. I'm embarrassed by them, and they in no way reflect the person I am today. And anyone who has gotten to know me, anyone who had a case before me at the trial court level, Court of Appeals, or at the Supreme Court knows that those comments that I made a very long time ago do not reflect who I am today.
What changed you?
The process of change, Mike, really started after I wrote those words because, as you can imagine, I received reaction from people. And I received some pretty thoughtful letters and comments from some gay students at Marquette. And I immediately realized how hurtful my comments were and how wrong they were. And that process of change started way back then because I'm not the type of person who wants to hurt somebody. And life changes a person. You get to know people. You hear about people's experiences, people who suffered discrimination, who were not treated fairly, people who come from different backgrounds. I didn't have those experiences growing up. So I learned, I grew as a person, I grew in my faith. And I just want to reiterate, my work at Children's Court, I interacted a lot with the LGBT community. I presided over adoptions for same-sex couples who were creating beautiful homes, safe and loving homes for children.
So you're saying you disavow those comments?
I absolutely disavow them.
Judge Kloppenberg, you have said that there is no statute of limitations on hate.
Well, what I have said also is that two sets of comments. I have been consistent throughout my educational and professional career, doing what I believe is right for my community and serving the interests of the people in my community and in the last 26 years, the people of Wisconsin. In 1992, when these comments were made, I was serving as an assistant attorney general, at the Department of Justice representing the interests of all of the people of Wisconsin. When I was 21, the age that these comments were written, I was in graduate school doing things like interning at the United Nations Security Council. I have been consistent throughout my career. And my opponent's career doesn't show much evidence of the change that she says she's had in her core values and beliefs. In 2006, when she was a practicing corporate attorney, she published an article that essentially equated contraception with murder. In this campaign, she has accepted as a critical, she's given a pivotal role in her campaign to Sheriff Clark, who has espoused his own set of very hateful and extreme views. And so we haven't seen in her career evidence of change.
I want to have you respond.
I think it's unbelievable that my opponent has the audacity to suggest that she can look into my heart and mind and say anything about the person I am. She has no idea who I am. And I found her comment that there's no statute of limitations on hate to be quite disturbing, because I think one of the most essential characteristics for anybody who serves in the judiciary is the ability to realize that people change, that there is redemption. When I was a trial court judge, I presided over 700 to 800 cases on an annual basis. I heard cases involving termination of parental rights, juvenile delinquency, child abuse and neglect cases. I interacted with people who had done some pretty horrible things, but for a judge to think that people can't change, that there is no power of redemption, I find that to be very disturbing.
To her point about, let me just interrupt. To her point about Sheriff Clark, he is very much opposed to same-sex marriage. He had some pretty hot statements right after the same-sex marriage ruling. He's helping raise money. What do you say to people who say, well, I don't understand. If she's changed, why this?
Mike, as I've mentioned, I have support all across the political spectrum. I couldn't possibly agree with everything that all of my supporters believe because I have a diverse group of supporters. I go back to my 2013 race when County Executive Chris Abele endorsed me and Sheriff Clark endorsed me. I think everyone understands they probably don't agree on a single thing. Just because somebody has endorsed me doesn't mean...
There is agreement on that, yes. They do not, yes.
Just because somebody has endorsed me doesn't mean that I endorse all of their views. And I also just wanted to point out that there is an organization that is providing substantial support to my opponent's race. That is One Wisconsin Now. And the executive director of that organization, I invite everyone, if they care to look at his Twitter feed. Scott Ross, the executive director, uses some of the most vile, sexist, and obscene language. So I'm wondering if my opponent, as she's receiving substantial support from that organization and from Scott Ross, endorses the comments that he makes, particularly against women.
My campaign is receiving no support. That is absolutely false from One Wisconsin Now. What we have seen revealed in the last week and a half are the words, the conduct, the choices that Rebecca Bradley herself has made. It is all fact. It's been reported in the papers, and now we are reacting to it. There is no indication, and it's totally untrue, that we are getting any support from One Wisconsin Now. My campaign has been focused on independence, integrity, and experience, the three things in which I am distinct from my opponent, and our message around the state has been to show how, through my background, where I got to where I am, my record as a Court of Appeals judge for 3.5 years, unlike the record of my opponent, whose time at the Children's Court cannot be reviewed because it is mostly confidential, people can see that I'm the candidate they can count on to keep partisan politics and special interests off the court and to make sure that the court works for all of us.
Final word on this, yes.
My opponent wants to try to define me by things I wrote 24 years ago when I was a college kid. And in response to last week's disclosures, I can't tell you how many people have said to me through phone calls, people I'm meeting, people who send messages on Facebook, boy, I sure don't want to be held to the things I said or did when I was a 20 or 21-year-old kid in college. People change, people grow. I have a demonstrated record as a member of the legal profession and a member of the judiciary of being an empathetic, absolutely fair judge at all times.
10 or
Yes, we're
15
talking
seconds.
to different kinds of people, because the people I've talked to, everybody I'm sure in this room is thinking, except for the students, thinking, boy, what was I saying when I was 21 years old? And many of us, most of us, have done foolish things, drunk maybe a little bit too much, drove a little bit too fast, said goofy things in our dorm rooms, but these were deliberate articulations of published positions, not just once, but several times, and they are choices that my opponent made and that she continued to make in 2006 and that she continues to make in this campaign, having Sheriff Clark help her raise money, walking off the bench to go talk to the Wisconsin Manufacturers and Commerce.
Do you think that's a fair comment now that we've learned from reporting in the Journal-Sentinel that another justice has done pretty much the same thing a few years ago, Justice Ann Walsh-Bradley?
I sure do. It's wrong. The justices are elected to do their jobs on the court. I argued many times in the Supreme Court. I've presided at oral arguments as a judge on the Court of Appeals. I brought externs to see lots of oral arguments. My colleagues at the Department of Justice argued, and no justice in those 23 years ever walked off the bench, because it's a dereliction of duty and it's an affront to the lawyers who have worked so hard to prepare for oral argument. Both my opponent and I spoke at the Jefferson County Bar Association a couple of weeks ago, and we both talked about how important oral arguments are. I know from personal experience that the give and take with the justices, I will, that the questions
No, really, let's give her a chance to respond.
are very, very important.
I'm going to play the role of moderator here and stop people.
I'll finish up.
Yeah, okay.
Thank you, Mike. As I've mentioned about my departure 10 minutes early from oral argument, we try to avoid that at all costs. Oral arguments are very important, but we also have the benefit of having Wisconsin Eye record every single oral argument. So in that one instance where I missed 10 minutes of oral argument, I was able to watch the video of it. I did not leave until I had all of my questions answered. I missed absolutely nothing. And I've been on the court now for 5 months. I've seen justices arrive late for oral argument, come and go during oral argument, and depart early. That was the one time. I think it's interesting that my opponent focuses on 10 minutes when she is promoting the fact that she's visited all 72 counties. She's always on the campaign trail. That cannot not have an impact on her ability to do her job.
Finish,
It hasn't. First of all, I have worked very hard to make sure I've stayed current with my caseload on the Court of Appeals. And I have an obligation to my colleagues to make sure we move our cases, and they have been moving since I have been campaigning. And it was more like 20 minutes of the oral argument that were missed.
Not true.
And the point is that just reading when my opponent says she read the briefs and all her questions were asked and she can just watch the oral argument afterwards, does that mean that she made up her mind before she left? Not giving, she may have other questions in response to the questions asked by her colleagues. It's a dynamic process, the oral argument, and what's still left 15 or 20 minutes in is the rest of the respondents' arguments and then the rebuttal arguments. And the questions that the justices ask are instrumental in making sure that all avenues of possible ways of deciding a case are covered. And it is fundamental that the justice's job is to ensure that the parties feel like they've had a fair shake. And how can they feel that way when justices get up and leave during oral arguments?
I want to...
I'd like to briefly respond, Mike, just on that point.
Quickly.
Justices approach oral argument differently. Some justices don't ask a lot of questions. Other justices are more active in listening to or posing questions. I was an oral advocate, too, and when I was an oral advocate as an attorney, I had something that I wanted to say that wasn't in the briefing. So I always appreciated when I had a panel of judges or justices who would allow me to argue my case. I like to listen to the attorneys who present their cases on behalf of their clients to us, and that's exactly what I do. Some people have compared me or called me the Clarence Thomas of the Wisconsin Supreme Court, as Justice Thomas is famous for not asking any questions.
Do you like that comparison?
I bring it up only because I don't ask a lot of questions. I ask questions when I have a question. I listen to my colleagues asking their questions, but I like to hear what the attorneys have to say.
I want to spend a little time here and there are many issues that we could talk about and some of the headlines that have been in the paper recently, but this is, I think, is important. My guess is that both of you would wish that these campaigns were more just focused on conversations about judicial qualifications, and we're focused on things other than what happened in your past or something that occurred in a particular case, ads that are running right now about you, Judge Kloppenberg. The question I have is are we doing this wrong in Wisconsin in the way we select our judges? Should we be looking, as 24 other states do, should we be looking at bipartisan commissions that make appointments to the bench to remove some of the politics, to remove some of the stuff that we see just about every time there's a judicial race? Judge Kloppenberg, I'll begin with you.
There's nothing wrong with presenting facts to the people of Wisconsin. I think it's a good idea for justices especially to have to go around and talk with people about what's on their minds, about how the court works, and their concerns about the court. But when you don't have facts, when groups don't have facts or want to hide the facts, then they distort and they mislead, as these ads that you've mentioned. There's some allies of my opponents who are running some ads. They've cherry-picked a couple of cases from the hundreds that I've issued since I've been on the Court of Appeals, and they have misrepresented and distorted the law, and they have misrepresented and distorted how the unanimous Court of Appeals applied the law in those cases. And my opponent knows how that goes. That's how the system works. And
so you're not soft in crime, as they are. Basically, that's the message here: is that you protect criminals and don't protect children. That's
what I
in the
do
first
is follow
two ads.
the law, and a review of my entire opus of Court of Appeals decisions will reveal that most of the time I rule in favor of the state because that's what the law says should happen. And some of the times there are errors made in favor of the defendant. And in all cases, I follow the law and I do justice. And these ads are inaccurate from start to finish, and they disrespect our judicial system and the judicial process we have in place to make sure that everyone is treated fairly. The cases they're identifying implicate issues of fundamental fairness, of the Constitution, of constitutional rights like due process. And fundamental fairness and constitutional rights and due process are not technicalities.
Justice Bradley, you were on talk radio a fair number of times in recent days talking about a story that you did not like in the Journal Sentinel. I guess my question is, it was a story that raised questions about your representation of a client with whom you'd had a relationship. I don't think for the entire audience we're going to have time to get into every detail of that tonight. But it goes to my larger point. This is what judicial campaigns have become in Wisconsin. This is what we talk about in judicial campaigns in Wisconsin. Should we be looking at appointing justices rather than electing them?
Before I answer that question, I need to respond to something my opponent said with respect to crime. She is suggesting that she's not really telling us where she stands on crime, but 5 years ago when she ran...
I'm against it, for the record.
5 years ago, when she first ran for Supreme Court against Justice Prosser, she told us exactly where she stood on crime then. She said, and I'm quoting Judge Kloppenberg, "Tough on crime is not my message." Judge Kloppenberg also said, "I never said I was tough on crime." The people of Wisconsin heard this loud and clear, as did law enforcement, and that is why I have received strong backing from law enforcement all across the state of Wisconsin. A majority of the sheriffs in the state of Wisconsin have endorsed my candidacy. Law enforcement in Milwaukee County, who know my work on the court system best, have endorsed me across the board. The Milwaukee Police Association, the Milwaukee Police Supervisors Organization, the Milwaukee Deputy Sheriffs Association, the Milwaukee Retired Deputy Sheriffs Association, yes, also Sheriff Clark, and our first responders in Milwaukee, the Milwaukee Professional Firefighters Association. So I think that gives the voters a good idea of how tough on crime this judge is. With respect to your question,
appointments
Mike,
versus
yes.
elections, yes.
I think the people of Wisconsin saw a new low in journalism, if I can even call it journalism. I think it is very telling that the forces that have joined together to support my opponent's campaign have gone back to not my judicial record, not my record as an attorney, but the things I wrote when I was a college kid 24 years ago. A relationship, who I dated 14 years ago has become an issue in this race. The fact that I went hunting a few months ago became an issue in the race. There is a reason they're talking about everything but my judicial record, because they're trying to show they're trying to hide the fact that I'm the first Wisconsin Supreme Court justice in state history to have served on every level of the court system as a circuit court judge, a position to which I was elected, a Wisconsin Court of Appeals judge, and now a Supreme Court justice. That particular article last Thursday, Mike, I want to address it because it became it was written as an article to suggest that I did something unethical or inappropriate in a representation of a friend. And that motion was made in that case, and it was a family law case. Many lawyers help their friends and family out when they have a family law case. And a motion to disqualify me from representing my client was made to a judge in Waukesha County, and that judge dismissed it.
With the benefit of hindsight, would you have done anything differently?
Absolutely not. What I did was very typical of attorneys to help a friend out in a family law action, and that motion was made as a tactical maneuver because I was so effectively representing my client that they wanted to disqualify me. The judge saw it for what it was, and it was dismissed outright.
Judge Kloppenberg.
Most of the lawyers and judges with whom I speak, the issue from those articles was the question of the exercise of Rebecca Bradley's judgment to choose to represent someone with whom she was romantically involved in a family law case, specifically involving a dispute over custody of a minor child who she knew and with whom she had spent some time. One legal commentator conceded that, yes, what she had chosen to do, the choice she had made, was permissible, but it was unwise. And this
so
was
you disagree with what the judge found in this case?
They had to go to
I don't do
Arizona
that.
to find the legal expert to say that. Not a Wisconsin lawyer, not a Wisconsin judge. It was shut down by a Wisconsin judge.
Was an exercise of judgment in a legal situation, and that's why it's relevant to what kind of justice she might be on the court. And I would like to say also that the quote about tough on crime was taken by Wisconsin Manufacturers and Commerce, spliced together a few seconds of a minute-and-a-half answer when I went on to say I was really tough as a prosecutor against violators when I was at the Department of Justice. And the question, what matters to voters when I go around the state is to be fair and to do justice and to make sure that everyone is treated equally under the law and that justice is dispensed fairly. And again, I am supported by the largest law enforcement association in the state and the professional firefighters and most of the judges, many more judges than Justice Bradley.
Very briefly, please. Mm-hmm.
I would like to respond. The article that was written by the Milwaukee Journal-Sentinel last Thursday was a vile piece of garbage masquerading as a piece of journalism. And I think it is very telling that no other news organization except the AP, which completely changed the headline because they realized it was a non-story, every news organization refused to reprint that article because it was absolutely disgusting. And I want to ask my opponent a question, because if the shoe were on the other foot, and if an article like that talking about my personal life from 14 years ago, if that was written about my opponent, I would have called her and I would have said, this is wrong. And I would have publicly disavowed it because I would have been so outraged that somebody demeaned not only me, but the Office of Justice and every woman in the state of Wisconsin by running an article that was a disgusting piece of filth. I would have called my opponent and said so. I would have publicly disavowed it. Judge Kloppenberg, will you disavow that article that was written on Thursday by the Milwaukee Journal-Sentinel?
Any article or reporting that has facts and that reports the choices that I may have made, the words that I said, the judgment that I exercised, is fair game.
Well, this is exactly what we saw 5 years ago, and I remember watching Justice Prosser and Judge Kloppenberg, then Assistant Attorney General Kloppenberg, during a forum much like this. There was an ad run, and I want to talk about this because I think
I've got
it is
30
very
seconds
that's
left.
fine.
Yes.
That ad was the most disgusting political ad run in state history. And the subject matter, the person who was the subject of that ad was a child sexual assault victim. And as an adult, he said that ad is a lie. I want it taken down. And I asked, and Justice Prosser looked at Judge Kloppenberg and asked her to disavow it. Okay. She gave the same response. We're seeing the same ugly tactics in this race all over again.
30 seconds, really. 30
There's
seconds.
nothing misleading or inaccurate about facts and about the words and the conduct and the choices that my opponent made. The ad she's talking about was a third-party ad that I had absolutely nothing to do with and didn't myself know about the facts. And as she has said many times in this campaign, and as I have said, we both said, we do not control, we cannot control what third parties do. They have a right to participate in these elections. The courts have said that money equals speech, and in that case, then voters have to be heard ever more loudly.
I'm going to have to stop right there. I'm going to have to stop right there because it is time for closing statements. And Justice Bradley, I believe, based on our coin flip, you go first here.
Thank you, Mike. I would like to thank everyone in the live audience tonight, as well as all of the voters and the citizens of Wisconsin who are at home watching this evening. I am by far the best candidate to continue serving the people of Wisconsin as a Supreme Court justice. I am the first Wisconsin Supreme Court justice in state history to have served at every level of the court system as a circuit court judge, a court of appeals judge, and now as a justice. I come to the bench having been called to serve the people of Wisconsin because I believe it is so important that we have justices on our state's highest court who are committed to and recognize their duty to say what the law is and not what we may wish it to be. That is the one commitment I make to the voters of Wisconsin. I will always follow the law regardless of how I feel about it or the outcome. It is my honor and my privilege to serve the people of Wisconsin as their Supreme Court justice. Thank you.
Justice Bradley, thank you. Judge Kloppenberg.
Thank you very much for paying attention to this very important race. The facts are that I have a proven track record as an independent and fair appellate court judge. I have a nonpartisan background. I have superior judicial and legal qualifications, and I have spent my entire career serving the interests of all of the people of Wisconsin. I ask all voters around Wisconsin to come together for independence and integrity on the court, things that I've stood for my entire career, for a justice who's qualified to serve on this court. My 3.5 years as appellate court decisions show everyone that I am an independent and impartial judge, and for a court that works as it should as the independent check and balance on the other political branches of government. I am the candidate that voters around the state can count on to bring independence and integrity to our Supreme Court. I've stood up for all of the people for 26 years. I ask that you vote for me so I can continue doing so as a justice on our Supreme Court.
Thank you. And with that, our hour is up. It was a quick hour. We want to thank the candidates for being with us tonight. We want to thank everyone at home for watching and those of you who have gathered here at Eckstein Hall. Our Conversation with the Candidates series has been a production of WISN 12 News and Marquette University Law School. Election Day is Tuesday, April 5th. We encourage you to get out and vote. For WISN TV and Marquette Law School, I'm Mike Goucher. Have a great night. Thank you to both of you. Thank you.
Thank you, Rebecca. Do it again on Friday.
Hang on 1 second.
This has been a special presentation of WISN TV and Marquette University Law School on the Upfront network of ABC stations in Wisconsin. Thank you for joining us.